Okay, good afternoon, everyone. Thanks again for coming. If you came to the last presentation on will making and probate, thank you for coming back. If not, don't worry, this is a whole new subtopic in will challenges that we're going to be discussing today. So you didn't have to review the last presentation to be able to be up to speed on what we're going to talk about today. My name is Peter Neufeld. I'm a partner at Wagner Sidlofsky, and I'm one of the co-chairs of this Lunch and Learn series, along with Professor David Friedman. Professor Friedman's also going to be speaking today with Harkert Singh Datta. Today, we're going to talk about the bases to challenge a will. So testamentary capacity, knowledge and approval, and undue influence. And that's going to be the topic for today. Just a few housekeeping notes. The first is that we prepared a brief blog for today's presentation. I'm going to have Maddie post that to the Zoom chat, so you should be able to access it if you want to review it. Please also have your microphones muted at all times, unless, of course, you're going to be asking questions at the end of the presentations. And then once you're done your question, we ask that you just mute yourself again. Please note, as you may have heard, the seminar is being recorded and a certificate proving your CPD hours for today's presentation will also be posted to the chat. And I'll have Maddie post that link momentarily as well. So I ask that you download it because we're not going to be emailing people the certificate this time. So as I said, we have two presenters today. The first is Professor David Friedman, who's a professor in the Faculty of Law at Queen's University and counsel at Wagner Sidlofsky. David teaches and writes in the areas of wills, estates, trusts, and guardianship law. He'll be joined by Harkert Singh Datta, who is an associate at Wagner Sidlofsky. Harkert obtained his JD from Osgoode Hall Law School and was called to the Bar of Ontario in 2022. And he practices both in estate and commercial litigation at Wagner Sidlofsky. Again, a big thank you to our sponsors, the B'nai B'rith, Concentra Trust, Scotia Wealth Management, Torkin Mains, TD, as well as BMO Trusts and Estates. This event is complimentary because of them. So thank you so much for contributing. And then to the participants, if you've enjoyed our seminar, feel free to make a donation to the B'nai B'rith Canada Food Program if you haven't already. The link for that will also be in the chat. I'm giving Maddie a lot of work to post all of these things to the chat, but thank you for doing that, Maddie. I see we've got Michael Mostyn again with us today. Thank you for coming, Michael. Michael's the CEO of the B'nai B'rith in Canada. And I'm going to ask that he, give us a little bit of a spiel about what the B'nai B'rith is, what the Canada Food Programs is. So Michael, if you're ready for that, take it away.
Absolutely. Well, thank you, Peter. Thank you to Wagner Sidlofsky, Chuck Wagner, and welcome everybody today to what I'm sure is going to be a very fascinating discussion. So as Peter just mentioned, and I raised last time, the origins of the B'nai B'rith food program, but this is a food program that is really helping those who have been left behind in our society. It is literally driven by volunteers because unlike many food banks, we have volunteers driving this food to those who need it the most, those who have fallen through the cracks. Our clientele for our food program really are those who are immunocompromised, food insecure, many of them very elderly as well, some of them suffering from other conditions that make them immunocompromised. But we have volunteers packing the food, the nutritious food, proteins, fresh produce, and in fact, in a mitzvah upon mitzvah, as we call it, approach, we have now begun to partner with other food banks in the city of Toronto so that any leftover food that the B'nai B'rith has from our clientele at the end of the day, we're now working with a group called Tropicana, which services the Caribbean community of Toronto, to ensure that any of our leftover food product do not go to waste, that they service other communities in need. And I know that it's provided a valuable opportunity for communities to begin working together in the joint work against hunger. We all need to work together. So for those of you who are celebrating a blessed Easter, a happy Passover, and once again, thank you, Peter, for this opportunity and for all of your consideration of support for B'nai B'rith and its food donation program.
Great. Thank you so much, Michael. Okay, we're going to start with the seminar. We're going to have David Friedman. He's going to start and he will talk about will challenges. Go ahead, David.
Thanks very much, Peter. Let me just start by encouraging everyone to consider donating to the B'nai B'rith initiative. I mean, it sounds like it's an absolutely wonderful effort. And for those of us that are overly food secure, I think it's a good thing that we give. So as Peter explained, this is the second in a series of seminars on the general topic of will challenges. So last seminar, we did the nature of a will and concentrated on due execution. This seminar, we're going to be talking about grounds for challenging a will and the probate process generally. And then future seminars will become, more and more specific as we go along. So today, the goal really is to unpack the model of law dealing with probate, talk about the substantive grounds for challenging a will, and try to unpack some of the traditional terms and doctrines which can be confusing. So we'll try to simplify things as much as possible. After we've finished making our presentations, it'll be our pleasure to answer any specific questions that you have. So I'd like to start by just talking about the sources of law in this area. In states, generally, we have a multiplicity of statutes and regulations with overlapping and concurrent jurisdiction sometimes. For our purposes for today, there's a few statutes that you should be aware of. There's the Estates Act, and the Estates Act sets out what the jurisdiction of the court is with respect to probate matters and controls who might be appointed to administer an estate in Ontario. The Succession Law Reform Act does a lot of things, but it deals with the formal requirements of a valid will and sets out provisions dealing with things like revocation of a will explicitly or by operation of law, or the requirements for a valid holographic will. Rule 74 and Rule 75 of the Rules of Civil Procedure are the old surrogate court rules, which have been just dropped into the general rules of procedure. And these are interesting because not only do they set out procedural requirements, but actually they create substantive jurisdiction of the court dealing with probate matters. So Rule 74, as you know, deals with non-contentious things like common form grants of probate, and Rule 75 is oriented towards the contentious business of the court, and that is, for our purposes, proof of wills in solemn form, that is by evidence. The jurisprudence fills in between all of these various things and sets out the nature of the grounds that can be pleaded to challenge a will, and things like the application of the equitable doctrine of undue influence, which I'm going to be dealing with at the end. So let's recognize from the outset that this is a technical area of law, and it is a complicated area of law, and that's by design. We've got three general objectives dealing with probate matters. First is we want to continue the approximation of laws between Ontario and other Commonwealth jurisdictions, both within Canada and outside of Canada. And this approximation of laws is what allows for grants of probate to be resealed in foreign jurisdictions and for foreign grants of probate to be resealed in Ontario because the laws are approximated. So this is really useful, and it's necessary, especially in a world where complex assets might be held across jurisdictions and where testators have property in various jurisdictions. The second objective is that we want to have maximum certainty and predictability. And that's important because that's what allows for estate planning. that's what allows for us to protect innocent third parties that might be dealing with an estate trustee. And we want to ensure that the transactions that they enter into are not impeachable later, which at the very least would prejudice the rights of those innocent third parties. So it's important that probate, once it's issued, is in fact a gold standard grant of a property right to the estate trustee. And the third objective is obviously to avoid fraud, because the potential for fraud in probate matters is quite high. And so the rules are technical for a reason. You know, can they be simplified? Yes. Should they be put into a comprehensive statute? Yes. But unfortunately, I don't think the legislature has any appetite for dealing with that anytime soon. And so we're going to have to carry on with the law as it is. So the first substantive thing that I'd like to talk about is the burden of proof in will challenges, and specifically the doctrine of suspicious circumstances, which is sometimes misunderstood. Last seminar, if you attended, we spoke about the nature of a will. And my colleague, Mukta Batra, talked about the law respecting due execution and how the law has been liberalized of late. Due execution of a will is important. When we say due execution, we mean execution that's compliant with the Succession Law Reform Act, facially compliant. And so due execution sets up a presumption of validity. And that's important because the vast majority of probate applications are not contentious and are not dealt with really as a judicial matter. They're dealt with as an administrative matter upon filing the proper forms and paying the proper taxes. Then eventually the grant of probate is issued administratively by the estates registrar of the court, whether a judge is involved in signing a document or not. And so that's what we call probate in common form traditionally. The presumption that arises on due execution is an evidential presumption. It's not a legal presumption. It's not an irrebuttable presumption of the validity. It merely says that where a will is facially compliant with the provisions of the governing statute, we presume that it's valid absent something else. And that something else can be evidence, or that something else can be evidence that qualifies as setting up suspicious circumstances, where the court is of the view that the will was made in circumstances that are suspicious. That presumption of validity is spent, and the applicant, the person, the propounder, to use the term that we use traditionally in law, the propounder is now obligated to prove the will by evidence on a balance of probabilities. So the question becomes, what do we mean by suspicious circumstances? I'm not one to want to read extracts of cases very often to a group of eminent professionals, but I'd like to read something from the leading case, which is Boughton Hay, which is a 1995 decision of the Supreme Court of Canada. And Justice Sapinka said this about suspicious circumstances. The suspicious circumstances may be raised by, one, circumstances surrounding the preparation of the will, two, circumstances calling into question the capacity of the testator, or three, circumstances tending to show that the free will of the testator was overborne by acts of fraud or coercion. Since the suspicious circumstances may relate to various issues, in order to properly assess what effect the obligation to dispel the suspicion has on the burden of proof, it's appropriate to ask the question, suspicion of what? So we're dealing with a jurisdiction that requires evidence to be brought with respect to circumstances that may excite the court's suspicion respecting the preparation of the will or its execution, or the circumstances by which the instructions are given to the lawyer. The Court of Appeal has held that the most commonly recognized example of a suspicious circumstance is a person who is instrumental in the making of a will and obtains benefit under it, and that was the authority for that proposition is Vanier and Vanier, which is a 2017 decision of the Court of Appeal. The jurisprudence, of which there is a lot, points to a number of factors that have been accepted commonly as setting up suspicious circumstances. And those include such matters as recent bereavement by the testator. So this is often the case of where the testator has lost a spouse and now makes a new will. Physical or mental impairment of the testator around the time that the will was made, and that's a fairly obvious point in terms of suspicious circumstances. Where the testator was dependent on beneficiary either for emotional needs or physical needs, so caregivers. Whether the will constitutes a marked departure from past distribution schemes and previously made wills. The factual circumstances surrounding the execution of the will and whether the beneficiary was involved in the preparation of the will. So I link this back to something I talked about in our first seminar, and that is the nature of the court's jurisdiction. In probate matters, the court has a special inquisitorial jurisdiction to inquire into the validity of instruments to ensure that probate is properly granted. And so the doctrine of suspicious circumstances merely calls upon the court to exercise its jurisdiction because of suspicions that arise, normally to do with the instructions that are provided to the drafting solicitor by the testator. And I want to emphasize a point that sometimes is misunderstood. Suspicious circumstances is a doctrine that operates to rebut the evidential presumption of validity that arises on due execution. It does not itself invalidate a will in whole or in part. It merely sets up the circumstances by which the court is called upon to inquire into the validity of the will. So suspicious circumstances doesn't render the will invalid of itself. My colleague Harkert Singh Datta will now review what's probably the most common ground for objecting to the will being admitted to probate, and that is lack of testamentary capacity. Harkert, over to you.
Thank you, David. So, as David stated, there are three common challenges to the validity of a will: lack of testamentary capacity, lack of knowledge and approval of the contents of the will, and the presence of undue influence. In this next part, I will focus on the lack of testamentary capacity. So the flip side of that is understanding what it means to have testamentary capacity. In order to have testamentary capacity, the testator must be of sound mind, memory, and understanding. It's not enough that a testator provides rational responses to a solicitor's questions. They must be capable of understanding and acting on their own initiative. The testator must also understand the essential elements of will making, which include their property, objects, persons who would be beneficiaries under their estate, and the revocation of any prior wills. When determining whether a testator had capacity to make a will, the Ontario Court of Appeal found that a competent testator does not have to know the precise makeup of their estate, but rather they have to have general knowledge of the nature and extent of his or her property. When challenging a will on the grounds of testamentary capacity, the legal test that the court applies is set out in an 1870 decision in Banks v. Goodfellow, also known as the Goodfellow test. The Goodfellow test provides that a person shall understand the nature of the act of making a will and its effects. A person shall understand the nature of the extent of the property which they are disposing. A person shall be able to appreciate who the beneficiaries are. And lastly, a person shall not be suffering from a disorder of the mind. The first three components of the Goodfellow test are essentially concerned with whether or not a testator has a basic understanding of what they're doing, whether they understand who the beneficiaries are, who their estate is going to, whether they understand what's in that estate, and so on and so forth. The last component, as to the testator's mental capacity, deals with whether the testator is of sound mind. For instance, in a case where a testator's affection for his son had been distorted by delusions of an international conspiracy, the court found that the testator did not satisfy the fourth component of the Goodfellow test. Numerous cases have dealt with the question of testamentary capacity. It has often been repeated that a testator must be of a sound disposing mind in order to make a valid will. Now, what does that mean? A sound disposing mind, the following characteristics can be extradited from case law. So in order to have a sound disposing mind, a testator must understand the nature and effect of a will. They must recollect the nature and extent of his or her property. They must understand the extent of what he or she is giving under the will. They must remember the persons that he or she might be expected to benefit under the will. And where applicable, they must understand the nature of the claims that may be made by persons that they are excluding from the will. It's clear from jurisprudence that the test to be met to prove testamentary capacity is a high one, and the onus falls on the propounder of the will. The jurisprudence shows that it's not sufficient simply to show that a testator had the capacity to communicate his or her testamentary wishes. Those wishes must be shown to be the product of a sound and disposing mind, as described above. It is only necessary to refer to a few cases to appreciate the level of capacity that is required. Will challenges on testamentary capacity are also require expert evidence. It's easy to allege testamentary capacity, but it's actually hard to prove it. It requires care and it requires the use of diligent experts. With that in mind, I want to now shift to discussing the role of drafting solicitors in will making. From a will challenge perspective, it's helpful if drafting solicitors are aware of the Goodfellow test and the basic components that courts consider when wills are challenged on the grounds of lack of testamentary capacity. To that end, it is helpful if drafting solicitors have detailed notes from their meetings with the testator, and they prepare questions that are designed to learn whether a testator has a basic understanding of what they're doing. Moreover, in cases where there may be uncertainty regarding the mental capacity of a testator, it's helpful from a will challenge standpoint if the drafting solicitor obtains a professional capacity assessment so that any suspicions surrounding testamentary capacity can be answered at the outset. The law is also clear on this point, that solicitors who undertake to prepare a will have a duty to inquire into the client's capacity. In Murphy v. Lanphier in the 1914 Ontario Court of Appeal decision, the court stated that the solicitor is brought in for the very purpose of ascertaining the mind and the will of the testator, touching his worldly substance and comprehension. So with that in mind, it's also important to understand some of the common errors that are made from a will challenge perspective. These errors have been the subject of criticism by the courts in the past and also the basis of liability for professional negligence in the preparation of a will. These include the failure to obtain a mental status examination, the failure to interview the client in sufficient depth, the failure to properly record or maintain notes, the failure to ascertain the existence of suspicious circumstances, the failure to react properly to the existence of suspicious circumstances, the failure to provide proper interview conditions. So, for example, the failure to exclude the presence of an interested party or beneficiary from the meeting with the solicitor, the existence of an improper relationship between the solicitor and the client, and this can include preparing wills for relatives, spouses, siblings, etc. And lastly, failing to take steps to test for capacity. From a will challenge perspective, it's important to note that drafting solicitors are in a unique position to actually create evidence that can defend a will if a will challenge is brought based on testamentary capacity. This can be done when the drafting solicitors are actually drafting the wills. So in some cases, you can see a will challenge coming on the basis of testamentary capacity. For instance, where there's a disinheritance of a beneficiary, or there are bad relationships between the parties. In these sorts of situations, it's likely that a will challenge can be brought. And like we stated earlier, one of the most common grounds and one of the easy to allege grounds is lack of testamentary capacity. Imagine also those instances where you're drafting a will for an elderly adult, and the common misperception is that adults suffer from, or older adults suffer from mental health impairments. This is a problem that can be spotted and headed off right at the outset. From a will challenge perspective, it's not enough to take notes of the instructions that you received from your clients, or even if you explained what options are available to the client and took their instructions on that. The drafting solicitor can and should also take notes that are relevant to testamentary capacity and the client's condition generally. So, for example, questions that would help in a will challenge situation are answers to questions like, how did the client present at the office when you met with them? Are they well dressed, or were they disheveled? Are they able to speak clearly and concisely or not? Do they have good hearing, or is someone translating for them? Are they relying on someone to answer your questions, or are they able to do so themselves? And do they need assistance from anybody else, or are they self-sufficient? Now, all the circumstances in the interview should be the subject of notation, because drafting solicitors can rely on that later on. Oftentimes, will challenges won't come for years after the will is drafted, and it's hard to recollect the exact situation and the exact circumstances of the meeting. If there are notes that can assist the lawyer in that situation, their evidence becomes all the more reliable. Notes as the surrounding circumstances and not just how to dissipate assets and what instructions the lawyer received would not only add to their credibility, but would help their will withstand a challenge on the grounds of lack of testamentary capacity. From a will challenge perspective, there should be standard operating procedure when dealing with older people, but also when dealing with cases where a will challenge is likely to be brought. Now, with that being said, I'll turn it back over to David Friedman to discuss undue influence during the creation of a will.
Thanks very much. If you attended the last seminar, we spoke about the unique nature of a will. So a will is unlike just about any other kind of document that's made as a matter of law. It looks to the future. That's to say that it's ambulatory. It can be revoked at will by the testator, and it obviously operates post-mortem. The principal grounds for challenging a will, lack of testamentary capacity, lack of knowledge, lack of approval, they all relate to essential items of the will that have to be present, and if they're lacking, the will can't be held to be valid. Undue influence is a little bit different. Undue influence is an equitable doctrine that applies to wills, and it applies outside of the testamentary context of wills as well. And so what I would like to do is I want to talk about just the doctrine as it operates, how it exists as a creature of equity, and then how do we go about spotting the red flags that are consistent with undue influence as a matter of practice and what we should do about them. So undue influence, this equitable doctrine, applies to both inter vivos transactions or the creation of instruments during life, as well as to wills. Inter vivos, undue influence applies presumptively. And it applies presumptively based on the special relationship that exists between two people. So, for example, most of the people that are attending today are lawyers. And as we all know, there's a fiduciary obligation that exists between a lawyer and his or her clients. It's a prototypical illustration of the fiduciary principle. And so we could say that one thing that differentiates, say, lawyers from waiters is not only are people happy to see waiters where they're not always happy to see lawyers, but if you give a gratuity to your waiter, it's not presumed to have been coerced. Whereas if a client gives a gratuity to a lawyer, it is presumed to be coerced. It is presumed to be a suspicious transfer of property. So the law of undue influence, when it deals with these sorts of things, is linked with our treatment of gratuitous transfers generally. So we know that where there's a gratuitous transfer from a property, excuse me, from one party to another, that sets up a presumption of a resulting trust. And so that transfer has to be explained. And the most common explanation is that there's a gift. And so intention to gift and delivery sets up a good gift as far as the law of property is concerned, as far as the law of gifting is concerned. But we're very suspicious about gratuitous transfers, specifically when it involves a transfer from one person to another where there's a special relationship between the parties. So in that case, undue influence asks a further question. It says, okay, if you brought evidence that sets out an intention to gift, well, how strong is that evidence? And what we're going to do is we're going to put a special burden on the transferee and say to the transferee, not only are we going to presume that you have to explain the transfer, but we're going to presume that you coerced the gift, that you received the gift improperly by doing something to coerce your client, in the case of the lawyer, giving you that gift. And so what it does is it fastens on the intention, and it asks for more in the way of evidence to provide an assurance that that intention wasn't procured improperly. In the testamentary context, we don't talk about presumptions of undue influence. There is no presumption that arises with respect to wills. In all cases in the testamentary context, actual undue influence has to be proved on a balance of probabilities by evidence. The second thing that I would like to highlight is that undue influence is an equitable doctrine, and that is important. It's an equitable wrong, and when it's proved, it will give rise to a jurisdiction to order an equitable remedy, which in the case of wills would allow the court to make an order setting aside the will or setting aside part of the will. So again, equitable wrong, equitable remedy. The equitable wrong springs from another doctrine that's important to understand. That's called equitable fraud. And equitable fraud and common law fraud are different. Common law fraud really responds to dishonest acts, deceit, essentially. Equitable fraud is much wider. It can respond to things like unfairness and unconscionability and things like that. So while courts of equity and courts of law have had a concurrent jurisdiction to deal with dishonest acts, equitable fraud goes a lot farther. And it really deals with situations in which a transaction or the creation of an instrument is somehow improper, and that the impropriety is not necessarily based on dishonesty, and that's important for our purposes. So undue influence in the testamentary context in respect of will making is something that we're traditionally told is akin to coercion, something that's not merely persuading a person to make a will in a particular form, in whole or in part, but something more. There's an old case that's commonly cited called Wingrove and Wingrove, which is an 1885 decision of the English Court of Probate while it still existed. And this is the principal authority that people use to cite for that proposition that coercion is what we're after. And the court said there that undue influence in the eyes of the law must be, to sum it up in a word, coercion. When the will of the person who becomes a testator is coerced into doing that which he or she does not want to do, and that's what undue influence is. So these claims then are about when one person overbears the will of another, and that's hard to prove. Our Court of Appeal, or excuse me, the Superior Court, has recognized that undue influence is often exercised in secret, and as a result, it's circumstantial evidence that is going to be brought before the court to prove the impropriety of the will. And so there can be the jurisprudence has accepted that certain situations are red flags, essentially, meaning that not only does it alert the court suspicion, but it also signals to us in the profession that we should be on the lookout for these red flags and be responding to them. So things like age, the fact that the testator is an older adult, or that the testator has significant health issues, or that the testator is isolated socially or has been recently bereaved, or that there's recent family conflict, or that, again, a departure from traditional will planning or the distributive scheme in previous wills. Other things are, I think, more pertinent for us, and that is situations in which the testator is reluctant to provide information or explain their intentions to the drafting solicitor. You know, is it because that person doesn't really understand, or is it because that person's been given a script and is told to stick to it and doesn't really want to elaborate for fear of revealing the pressure that's being put on them, often by a child or a person that is providing care services? So these common scenarios really deal with vulnerabilities, the vulnerability of a testator to be pressured by another person. And in dealing with our clients, it's important for us to interview them and to be sure that the instructions that they're providing to drafting solicitors are in fact their instructions and not the instructions of someone else. And to spot undue influence or to spot these red flags, it becomes necessary to interview the testator at some length. And one of the things that I habitually bang on about as a way to avoid liability and ensure that we're adequately serving our clients is to have systems in place and to have people that are interviewing our clients with respect to their will making instructions that not only want to capture accurately what those instructions are or what property is going to be subject to gifts in the will, but to understand the circumstances of the testator and why those instructions are being given. And when we understand those circumstances and we inquire into them, we're able to identify where there's these red flags present in respect of undue influence and respond to them, to make inquiries, to then document the fact that we had suspicions, excuse me, ask questions, and that the information that we received dispelled those suspicions. And this becomes really important as evidence later where the will is being challenged on the basis of undue influence. So we have rattled on for about half an hour now, and we have time to discuss the issues with you. If you have questions or if you have comments that you're prepared to offer, we'd be happy to answer your questions or respond to your comments. And I will turn it back, I think, to Peter, who will be in charge of all of that.
Sure. I'm happy to field any questions that anyone has. You know, David, I've got a question for you. You were talking about equitable fraud a lot, and I was wondering if you could go into that a little bit more. You know, I understand that equitable fraud can be applicable to inter vivos transactions, but from what I got from your discussion was perhaps it can apply to dealing with a will as well, and perhaps it's, you know, involved in the assessment of undue influence.
Sure.
On that basis, you know, if equitable fraud is so much more broader and not just, you know, deceit like common law fraud, that seems to put drafting solicitors in kind of a tough spot when they're trying to figure out how to assess whether there is, you know, equitable fraud that exists. I mean, how the heck would they even go about figuring that out?
Sure, and perhaps I haven't been as clear as I could be. equitable fraud is a doctrine in equity. And as we know, equity is different than common law. Equity doesn't deal just with property. Equity deals with people, and it gives rise to all kinds of doctrines that we use to test whether transactions are valid based on considerations like unconscionability. The equitable fraud is itself not a wrong, though. So an example of a wrong that proceeds from equitable fraud is undue influence. Equitable fraud, though, is the basis of the court's jurisdiction in this area. So when we say, is a will valid, we can understand that in terms of validity in the sense that it complies with the forms that are required under the governing statute, in our case, the Succession Law Reform Act, but also then whether it truly is an instrument that was made by the testator. And we can test that, again, through various doctrines, one of which being undue influence. So the thing that can drive you a little bit crazy in dealing with equity is it has softer standards. You know, things like unconscionability or fairness compared to, you know, common law fraud or deceit or something like that, where we have constituent elements that are really like very hard black letter law. It's a little bit different, but for our purposes, I think that in challenging wills, what it reveals is that the court has a jurisdiction to consider all manner of circumstances that may, after inquiry, yield the conclusion that the instrument wasn't actually the product of the free will of the testator. So it's not necessary for a drafting solicitor to inquire into all aspects of his or her client's life. What is required is to inquire into circumstances where the making of the will seems to be at odds with either what the client has done in the past or what a reasonable person would expect the client to do now. And so there is an overlap between lack of capacity and undue influence, because it's a lot easier to coerce a person that has diminished capacity, and their diminished capacity might be sufficient to say that in and of itself makes the will invalid. But the larger jurisdiction and undue influence, this more, you know, nebulous way of being able to go forward to consider whether in fact the will is valid or not. It's not that the drafting solicitor has to satisfy themselves that everything is perfect in the client's life and that they're making rational decisions, but rather to ensure that there's nothing that is present that would yield an unconscionable result. And that's what equitable fraud is about. It's about the court's protection of the vulnerable. And so if we can respond to circumstances of vulnerability to ensure that there is not exploitation, then we can dispel allegations after the fact that the will was procured by undue influence. And I think that that's something that drafting solicitors can and should do. And I hope that's responsive.
Thanks for that, David. That was great. Again, if anyone else has any questions, feel free to pose it. You can put it in the chat, or you can just go off mute and ask it.
Hi, can you see me? Oops.
We can see you.
Okay.
If you could speak a little bit louder, I think that would be helpful.
All right, so my name's Hyann. I'm an Ottawa lawyer. Just question is, can you challenge a will due to lack or insufficient provisions for dependents? And if, in this case, if you have when you do this, it's typically when you have common law situations, right? For the family, if it's a spouse, you can go through the separate route.
Okay, so it used to be a long time before that we had present dependent support legislation. The way the courts would approach this is one that was about validity of wills. They would say, oh, the testator did fail to leave support for his wife and children. Obviously, he's insane. He forgot that he had a wife and children, and therefore the will is invalid. Since 1929 in Ontario, when the first dependence relief legislation came in, there is a jurisdiction on the part of the court to order support out of the estate. And this is Part 5 of the Succession Law Reform Act. So that the failure to provide support for dependents doesn't of itself affect the validity of wills. So challenging the will because of the lack of support to dependents, one can't challenge the will based merely on a lack of support to dependents, because those dependents will have a claim that is available to them under Part 5 of the Succession Law Reform Act. But, you know, again, the failure to provide support to dependents can constitute a suspicious circumstance and might in fact be relevant to making out undue influence, where someone else unduly influenced the testator to make their will specifically not to provide support to dependents. And there's, you know, interpersonal dynamics between the undue influencer and the dependents. And so in situations involving, you know, all estate litigators' favorite situation, the children of the first marriage against the second surviving spouse, you know, are there dynamics between those two groups of potential dependents that would allow for one or the other to put pressure on the testator to exclude the spouse or the children, as the case may be? So they're different. Failure to provide dependent support doesn't itself affect the validity of wills, but the reasons for failing to provide support for dependents may very well lead to the court to conclude that there are suspicious circumstances or there's been undue influence. And I hope that is responsive. And if it's not, show me a little mercy and give me another try.
I have a follow-up question on that. You talked about the conduct of the testator. You know, they habitually do different things. That would be in terms of how they treat their family members. But is the history of the testator's conduct vis-a-vis lawyers? For example, if a testator has done everything in his life with one lawyer and suddenly goes to another law firm to do a will, would that be suspicious circumstance?
May very well. And I would suggest that if you have an older adult, especially, or someone that you think might be vulnerable as coming to you for a new will, I mean, the first question I think that I would ask is, if you've made wills in the past, why aren't you going to the lawyer you used previously? I mean, if that lawyer has passed away or is retired or is no longer practicing in that area or something, that's fine. But I mean, it clearly is a suspicious circumstance for me, coupled with where there's a new lawyer involved and there's been a departure from the existing estate plan. That's something that I think that the drafting solicitor should inquire into and be alert for, because that's exactly the kind of thing that happens where there's undue influence. The person that's being coercive shops around for a lawyer that's not going to ask questions and going to facilitate the making of this new will. And often, unfortunately, that second lawyer may be a recent call or somebody that doesn't really practice, you know, very much in this area and is unwittingly duped into becoming the person that facilitates this form of fraud. So, you know, if I would suggest that this is something that should be inquired into, and the answers of the client should be noted in the file. And it may very well be that the solicitor feels uncomfortable in drafting the will in those circumstances, especially if the client is going to be evasive and doesn't want to explain why it is that a new lawyer is being retained out of nowhere. So I hope that's helpful.
What if you can't find out if there's any, in the past dealings with the previous lawyer, if there's any dealings on estate planning, but other areas, like if I have business or I purchase properties, I always go to the same lawyer, and suddenly my will is done through another lawyer. Would that?
Well, there might be a perfectly adequate explanation. And I think it's merely asking, asking the client why, and explaining to the client what your concerns are. I mean, are you coming to me to draft your will because you're unhappy with your existing lawyer? And that's fine. Tell me what you're unhappy about, and I'm going to make sure that I don't commit the same sins. Or is it a matter that something else is going on? And if you can't get a straight answer, and you begin to get and these other factors fall into place, then I think you have to seriously ask whether this is a retainer you're willing to accept. But the fact that that a person used different lawyers for different things, that's perfectly proper. Or a client may have gone to a lawyer, through an insurance company benefits package, chose a lawyer that was at a rather less expensive price point in the past, or whatever the case may be. There should be some explanation, I think, that will allay any suspicions that you have.
What about drafting a will for your family? You become a lawyer and you say, well, I'll draft your will.
For your family?
Yeah.
Okay. This is a matter that you're gonna have to decide upon. But
I'll note, David, we've got about 3 other questions in the chat
alas.
in about 6 minutes, so I may need to go on to another question.
Okay.
All right, so the first question: how does a drafting lawyer determine a caregiver bequest is undue influence? A senior that relies on a caregiver will always feel influenced, or at least very likely.
Boy, this is a topical area. BC has legislation on this point exactly, with respect to caregiver requests. When there's all kinds of cases that have emerged over the last number of years dealing with undue influence and caregiving, threats to withdraw care as a means of obtaining a gift. There's a case called Marsh Estate in Nova Scotia about this, and a case in Ontario, Pascu, I forget the name of the case, on threats of withdrawal of care services. I think that the job of the lawyer is to ensure that the caregiver is not taking advantage of the testator, or that what's happening is a failure to formalize an informal arrangement. So let's say you have a testator that has a number of children, one of whom is the principal caregiver, and the testator wants to give a more generous interest in the estate to that child. Well, that can be documented. If it's, let's say the caregiver is not a child, but let's say it's a neighbor. Well, maybe the better approach in that case is to set up a contract for caregiving services, and rather than having a gift in the will, actually having payment that's going to be made, but going to be made after the person dies out of their estate. Where there's a gift to a caregiver, certainly I think that one should be on the lookout for coercion, but it may be perfectly proper. And I think that a great deal of attention should be paid to that gift if it's in fact a significant one.
Right. Thank you for that. I've got another question here. It's a bit of a long one. I think to distill it, the question is, can a court determine suspicious circumstances on its own without a notice of objection being filed? So would a court ever unilaterally say, this doesn't seem right. I'm gonna ask that the propounder of the will explain these suspicious circumstances, even though a notice of objection hasn't been filed?
In principle, yeah. I mean, you apply for probate over a will that's a holographic will. So now we don't have a presumption that arises on due execution. We have facial compliance with the statute if it's wholly in the handwriting of the testator and signed. But it still is up to the court that's reviewing the application to inquire into any areas in which the judge might feel that there's a suspicion that something is wrong. I mean, certainly we're going to need to have proof with respect to handwriting and where the will was signed and all the rest of it. And that's a circumstance where you have a common form application that's being brought, and where something more might be required. The court, exercising its inquisitorial jurisdiction, wants to ensure that this is in fact the last will of the deceased and it's a valid will. If, however, it gets before the court, there's an application and the court looks of itself and says, I need more to determine whether this is a valid will, and I'm going to direct the applicant to satisfy me, then that's a perfectly proper exercise of the court's inquisitorial jurisdiction. Like, again, this is an area where courts have a special jurisdiction that's different from the normal one. The normal one is they're just adjudicators, umpires, fairly applying the law, fairly finding the facts based on the evidence. In its inquisitorial role, the court can say to whoever's applying for probate, you need to satisfy me that this is a valid will. And if I have a suspicion, I'm going to direct you to provide me with evidence on point to allay my suspicion. Otherwise, I'm not going to grant probate. And that is perfectly proper. Pragmatically, I don't know how it's going to actually arise without the objection, but obviously it can in appropriate circumstances.
Yeah. All right, I'm going to try and squeeze in one more question. Are you aware of any case law? I'm holding you your feet to the fire now. Are you aware of any case law about a lawyer being accountable for drafting a will that is not signed in their presence? So, for example, they're out of the office and the signing of the will was coordinated by the newly appointed executor.
I don't have a case off the top of my head, but certainly, I mean, the question arises as a matter of professional negligence. The lawyer has a duty to act competently, and that means within to have the will executed in a manner that complies with the statute. If they've delegated that to office staff, then certainly they can be liable where there are problems that arise. I don't know whether that answers the question or not, but if the will has been sent out for execution and the lawyer has said, well, I don't want to do this, or I don't recommend against it, but here's how the will should be executed with witnesses, and then it should be kept safe or returned to me, or whatever the case may be, then that's appropriate, because the work of executing or supervising the execution of the will is specifically outside of the retainer that exists between the client and the lawyer. It's a really bad practice, though, to allow the will to be sent out for execution elsewhere, and I wouldn't recommend that you do that. That's all kinds of mischief can happen, even within offices. There are problems ensuring that the will has been executed properly. Sending it out or the lawyer allowing it to be executed outside of their presence, you're setting yourself up for problems. I wouldn't do it.
Peter, I'm sorry, just to jump in. I know you were ready to end it up, but there's a question that I think really everybody in the group would like to hear an answer to. If the drafting solicitor suspects undue influence, but is unsure, do they have a duty to walk away from the retainer, or do they take it, or they just take copious notes? What do you think?
Who's you?
My friend, Professor David Friedman.
Oh, me. Great. Great. Stump the chump. What do you do? Well, this is a matter of professionalism. If you suspect that something is amiss, then it's entirely within your right as a professional to withdraw your services. On the other hand, I mean, obviously, we're here to serve our clients and we don't want to make things more difficult for them. If you feel that you have suspicions, but you've asked questions and you noted what the answers are, I think it would be appropriate to continue on with the retainer, but I would write a letter to the client, setting out what the nature of your suspicions are or your uncomfortableness with the will, and advising that the will may very well be challenged later after the fact, and recommending what could take place to avoid that happening. So that's a judgment call for the lawyer to make, and one that should be made based on their own self-interest, because one doesn't want to become disciplined or involved in litigation for continuing on with an assignment where there's a strong suspicion that something improper is happening. I think again, this becomes a matter of basic professionalism. We're not robots, right? We don't have to do whatever our clients want just because they're giving us instructions. They're giving us instructions to do something that's either improper by virtue of the rules of professional conduct, or improper as a matter of law, or otherwise. We can refuse those assignments. Where it becomes a little bit more pointed is if the circumstances are like a deathbed will or something like that, where you don't really have a lot of time. And unfortunately, you're really not going to like the answer I'm going to give, but it's the one that I have to give. There's two kinds of problems in the world: my problems and your problems. Don't make your problem become my problem by getting sued.
I very much like your answer. I just want to add one thing. If you are if you feel that the issue is too much for you to decide on your own, don't hesitate to reach out to senior counsel, or if you're senior counsel to other of your colleagues, and get their guidance and advice on it.
Right. All right. Thank you very much for the questions. That was great. Thank you, David. Thank you, Harcourt. Thank you, everybody who asked questions today. I think this was a great session. Maddie will correct me if I'm wrong, but I believe our next seminar is going to be on April 26th. Maddie, nod if that's correct. All right. It's going to be on notices of objection. So we're going to have a bit of a break between now and April 26th. We look forward to seeing everyone there again. Thank you again for coming out, and we'll see you next time.